Hello, I'm Dominic Walker, JMW's Inside Man. My guest is Ewan Cooper. Ewan is a solicitor within JMW's Commercial Litigation Department, and one of the areas that Ewan specialises in is business interruption insurance claims. So I believe, Ewan, that there's been a recent development in business interruption insurance claims. Can you just give us an idea of what's happened, please?
Yeah, that's absolutely right. So business interruption insurance in the context of COVID-19 has been back in the focus of the courts in the case of Corbin and King and AXA. So Corbin and King ran 8 restaurants and cafes which had to close due to the restrictions that the government put in due to the COVID-19 pandemic. They then made a claim against their insurer for the business interruption insurance losses under their insurance policy. Now, specifically, this policy provided coverage for the actions taken by the police or any other statutory body in response to a danger or disturbance at your premises within a 1 mile radius of those premises. And this is known as a non-damage denial of access clause. Now, this non-damage denial of access clause also had a limit of £250,000. So just taking a step back and looking at this area more generally, in the FCA test case, the High Court held that the majority of non-damage denial of access clauses provided a narrow, localised form of cover, which did not respond to the circumstances of COVID-19. But when this issue was raised in the China taping arbitration, Lord Mance sided with the policyholders and effectively opened the door for the courts to examine this issue more fully. So in the Corbin and King case, there were 2 main questions before the court. The first was whether the non-damage denial of access clause provided effective cover for losses flowing from restrictions from the claimant's 8 restaurants. And secondly, if it did provide that cover, whether the limit in respect of those losses would be applied to all of the premises or whether the limit applied to each individual restaurant. So on the first question, the court held that COVID-19 was capable of being a danger within a 1 mile radius of the insured premises. Coupled with other uninsured but not excluded dangers, this led to the regulations which caused the closure of the businesses and caused the business interruption loss. So Corbin and King were therefore covered for their losses under the non-damage denial of access clause. And this then raised the second question to do with how the losses should be calculated. Now, AXA had already accepted that a fresh limit would apply in respect of each of the new set of government regulations. But they argued that the limit applied to the business as a whole rather than each restaurant individually. Now, on this issue, the court also found in favour of the claimant, and this was for 2 reasons. The first being that the insured's interest was to be analysed as a composite policy. So as such, the policyholder was successful on both of its arguments. Firstly, for the coverage under the non-damage denial of access policy, and also on the limits of the policy.
Now, there will be policyholders watching this who weren't able to make a claim on the business interruption insurance claim. What does it mean for policyholders?
Well, this decision should be well received by policyholders whose claims under non-damage denial of access clauses have been rejected by their insurers. And this could lead to policyholders considering requesting that their insurers review the claims that have been rejected on this basis.
So at the beginning, I mentioned that you specialise in business interruption insurance claims. How can you and the team help those policyholders who haven't been able to claim on their business interruption insurance policy?
Well, at JMW, we've got experience acting for policyholders, and we've got a dedicated website for business interruption insurance disputes. We're inviting in policyholders who think they might have a claim to register their interest with their details on our website where we can review potential claims.
Ewan, thank you so much for your insight. And if you'd like to speak to Ewan a little bit more, as he says, the website is the place to go, or you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.